Advai, what is PDPL? What is the full form PDPL?
So PDPL stands for Personal Data Protection Law.
To transparency, they need to collect every piece of data, which is against the principle of data privacy.
Exactly. Yes.
So policy is done, DPO has been done, committee has been created. Anything else we need to add?
Absolutely. This is just first step.
What is the reporting authority of DPO?
When a client is specifically bound by NTMO requirements.
How we handle that if we have so many processes? We go by scenario-based risk assessment?
Like, no, we go department by department.
So as like so we did with the risk treatment. Then what is the next thing now after that?
Managing the compliance requirement on a day-to-day basis.
Hey team, welcome to the session on Coffee with Prabh. And today we have a special guest, not a guest, he is my brother, Mr. Suhas Krishnamurthy. We already did one session in the past on how to implement privacy management system. And we are here again with the new topic, how to comply organization, or what is the Saudi PDPL, Saudi Arabia PDPL, the new privacy regulation, which creating a lot of buzzword. And in this particular podcast, we're going to discuss about how to prepare organization to be comply with PDPL. And when you're talking about Mr. Suhas has a 10 plus year of experience in data privacy, and he known for his writing his data privacy context in LinkedIn. Currently, he is stopped, but I believe he's going to start again very soon. And the first podcast I did with Suhas, because the guy was doing a lot of writing on data privacy, and that fascinated me to invite him in the podcast. And in one shot, we got an opportunity, and he was in a session.
Thank you so much, Prabh, and it's my honor to be on your podcast. Honestly, I listen to all your podcasts, especially when it comes to GRC and data privacy.
Thanks.
Right? And your recent podcast on GDPR was also really good, and which I obviously tell anyone who wants to start a career in data privacy to go through that podcast to know what exactly data privacy is. So you're no less than I am in the field of data privacy. You're also an expert.
No, I am a newbie in the data privacy, and that is why you are here. And I want to learn more about PDPL, which is creating a lot of buzzword. So otherwise, what is PDPL? What is the full form PDPL? And can you just explain this in more basic manner, because there's a lot of audience who watch this podcast who come from a non-GRC background also. So what is PDPL, and what is the significance of PDPL in Saudi Arabia?
Okay. So PDPL stands for Personal Data Protection Law, and the Kingdom of Saudi Arabia realized that since there is a lot of technological innovation happening, there is a lot of data sharing happening across different geographies. It was vital to set up a global standard for protection of personal data of the residents of the Saudi Arabia. And that's where Saudi Data and AI Authority, they developed something called as Personal Data Protection Law, and it came into enforcement on September 14, 2023. And all the organizations which were to comply with this particular regulation had a grace period of about 1 year, which means that organizations had time till September 14, 2024 to comply to this particular regulation, right? Now, this was particularly pertaining to the law and the implementing regulation. So how SADAIA has basically divided this whole regulation.
What is that? The statement you said?
Yeah, so, SADAIA. SADAIA is basically the regulator. It is Saudi Data and AI Authority. Right? Okay. So we acronym it as SADAIA. And this regulatory authority, what they did is they went beyond the standards, and what they've done is they first released the law, which is the basic requirements from a data protection perspective, which contain 47 articles. Right. Now, after that, what they did is, in order to substantiate and guide the organizations on how to implement the controls mentioned in the law, they released something called as an implementing regulation. Now, this implementing regulation contains 37 articles, and this has detailed explanation of how data subject rights are to be taken care, how data breach has to be managed, how consent has to be managed, and so on and so forth, end to end, right? Now, the regulator did not stop there. They wanted to go even beyond that to ensure that organizations are complying to various requirements. At the same time, they get the required help from the authority. So they started developing various rules and guidelines, right? Rules are something which are absolutely mandatory to be implemented by the organizations. And they also started releasing guidelines, which are basically good to have in an organization, right? Now, in the past about 2 to 3 months, the regulator has released almost 8 to 9 rules and guidelines, And these are very, very crucial for an organizations to go through and make sure that their data protection regime is in alignment with these rules and guidelines as well. Even though the authority says that there are guidelines are not mandatory, uh, we would strongly encourage all the companies to go through those guidelines and ensure that even at not immediately, but in the future they align to these guidelines, because we never know, these guidelines might become a part of the law tomorrow, right? So it is very, very essential for any organization which wants to comply to the regulation to be aware of all the law, implementing regulation, the rules, and the guidelines, all four of them.
Okay. So if my company is based out in India, registered in India, doing a business in India, and we have a customer from Saudi. Okay, he want to subscribe to my training. He want to subscribe to my consulting services. Will the DPDPL, whatever regulation we have, is it applicable?
Absolutely. So PDPL has the
PDPL,
extraterritorial effect. It has the extraterritorial effect, which means that if any company outside the jurisdiction of the kingdom is actually processing personal data of any data subject within the kingdom, right? In that case, PDPL regulations will have to be complied with, right? Irrespective of whether that organization is a controller or whether it is a processor. So there are certain contractual obligations, there are certain regulatory obligations to be fulfilled, and they will have to follow the PDPL regulation.
Okay. So, Suhas bhai, like, when I'm talking about in GDPR, we have some category of the organization. If you have this parameter, you need to be comply with GDPR and all that. So, do we have same thing in a Saudi privacy regulation?
See, it is pretty simple and straightforward when it comes to Saudi, right? If a company is processing personal data or sensitive personal data of any resident of the Kingdom of Saudi Arabia, then PDPL is applicable, right?
Okay.
So the only distinction, only cases where PDPL will not be applicable is personal data is being used for, personal reasons. So, for example, if you're, uploading something on your personal blog, which is not used for commercial purposes, right? In that case, PDPL is not going to be applicable. However, if it is going to be something for commercial purpose, if it is going to be something for the benefit of the organization, then PDPL is definitely going to be applicable. So it's pretty straightforward. So if you take any legal entity within the kingdom or outside the kingdom which is going to process personal data of the residents of the kingdom, then PDPL is going to be applicable.
Okay, so it will be like a resident of Saudi Arabia.
Resident of Saudi Arabia.
PR holders and citizens.
That's correct.
Okay, so Suhas bhai, like, I want to start an organization in Saudi Arabia, in Riyadh. And I invited you, Mr. Suhas. You are a privacy consultant, and you want to make sure that you prepare my organization to be comply with Saudi privacy regulation. What is the first step, and what is the last step?
Okay. So it goes without saying, Prabh. So similar to what we spoke in the PIMS, podcast. The first step to any data protection regime is always, creating the data inventory and understanding the personal data landscape, where exactly personal data lies within the organization, whether personal data, flows outside the organization, whether the personal data flows outside the kingdom, right? Whether the organization is using any cloud service provider, whether everything is on premise. So it's more about understanding the personal data landscape. So once you understand the personal data landscape, that is when you can actually start evaluating the requirements from your organization perspective, right? Now, then you start developing the governance which is required. Now, the governance also completely depends on the personal data landscape you're having. Suppose you're having a conglomerate or a multiple entity organization governed by a group company. In that case, how you have to define your governance structure, whether it has to be federated, whether it has to be centralized, whether it has to be decentralized. So all these things comes into picture once you analyze your personal data landscape. And once you have the governance structure in place, once you have the required mechanism and the approving authority in place within your organization, the next logical step is for you to start developing the required framework for PDPL. Now, when I say framework, this is going to contain a lot of policies and procedures, because as with GDPR or any other regulation, there are multiple angles to the PDPL, right? The first thing is, of course, periodical impact assessments will have to be conducted. When
But
impact
Shivas, before that, I want to stop here. I want
yeah.
to ask you about, when you said data inventory need to be done. Example,
Mm.
okay. Can you just share one example? Like, because as I said, not everyone come from a data privacy background. So when I say data inventory or data classification, can you give us one example with that? Can you be able to explain that?
Absolutely, yeah. So, see, an organization contains multiple processes, right? So, it might one example you can take is maybe HR onboarding process when an
Hmm.
employee wants to join a new organization, right?
Hmm.
In that case, there is a exchange of data between the organization and the prospect or the employee who's going to join, right?
Hmm.
In that case, we know that this is a process, and this process entails sharing of data between two parties, right? Now, what all data can the organization request in order to enable the joining of that particular employee? Right now, this can be the basic information of the
House address, phone
candidate.
number, email
Yeah,
address. Yeah.
it can be that. Second thing can be they can also ask for sensitive personal data, such as
Hmm.
criminal records to have
Hmm.
background verification. They can there are few organizations which also ask for health reports,
Hmm.
whether the candidate is actually fit to work in the organization or not. So a lot of information can be collected, right?
Hmm.
Now, how this information is handled within the organization is what is to be understood through data inventarization or data identification. Now, this data, first of all, once collected from the candidate, can first of all will go into the onboarding platform of the organization. Now, this onboarding platform might be cloud hosted or it can be on premise, depending on the
Hmm.
type of organization, right? Now, even if we take cloud hosted platform, whether the vendor who's providing the cloud service has access to this particular platform or not, right?
Hmm.
That is something which has to be understood. Now, if and again taking the same example, if it is cloud service provider, whether the cloud is within the kingdom or whether it is outside the kingdom, right? If it is outside the kingdom, whether that particular region has adequate level of data protection or not, right?
Okay.
And if it is on premise, how strong are the security controls and how strong are the privacy controls implemented within the organization, right?
Okay.
And once the data is collected, if the candidate joins, then for after the candidate leaves or the employee leaves, how long is the data retained and when it is deleted? If the candidate does not join, then for how many days or how many months or how many years the data is retained, right? So like this,
Hmm.
there are various metadata which has to be analyzed before you actually take a decision on how to form the complete governance structure and the framework for the organization. So this is what is called as data inventarization, where you understand what data is being captured, what personal data is being captured, how it is processed, where it is stored, where it is retained, where it is shared, and how it is going to be discarded.
Okay. That. Sorry for that, because it is very important. People should know when I say data inventory, it should not be only the collected data we have, because this is something we do from a preventative perspective also, because we follow the data minimization principle, because more data you collect, more accountability comes to you. So that's the reason. Okay. There was a one, so after doing a data inventory,
Mhm.
okay, what is the next step?
So the next logical step is for us to see how to govern the particular program, right? So developing policy comes generally what happens is there's a confusion between developing policies and establishing governance, right? But
Hmm.
what I always strongly encourage is having a strong governance structure in place and then go ahead with developing of the framework. And this is so
Hmm.
because you need to have accountability in the organization, right?
Hmm.
Once you have the accountability in the organization, the framework will be strong enough to be implemented across the organization. Now, the governance structure, again, as I mentioned, can be of three types, Prabh, right? Depending on the organization structure, depending on the budget, depending on how the current structure of the organization is, right? So if it is something, a very huge group company which contains multiple entities under them, right? Then a single DPO might not be able to handle all the data protection issues across the organization.
Example.
Uh, you can take any
Sorry,
example.
you met a wrong student today.
You can take any example. You can take any industry within India as well, right? So, for
Okay.
example, if you take Reliance Industries or Tata Group or any company where they have multiple lines of businesses, right? Now, in that case, a single DPO might not be able to fulfill. Again, I'm not sure how their structure is, but I'm just
Hmm.
giving an example. So they might not be able to completely fulfill the data DPO duties for all the lines of businesses,
Hmm.
which is where multiple DPOs might be required to govern the complete program. and these DPOs can be appointed depending on the similarity of the lines of business, right? For example, if for there are suppose 4 or 5 BFSI companies within that group, they can have a common DPO. There are 4 or 5 retail companies within that group, they can have a common DPO, right?
Okay.
Again, the regulation does not prescribe any structure. It is completely on the organizations to understand their data protection maturity and accordingly form the particular governance structure.
Okay.
If the organization is small, right, there are very few customer base. There's not much of data protection activity. Sorry, there's not much of personal data processing happening, right? In that case, they can even appoint an external DPO as a consultant, or they can hire a privacy manager. A DPO might not be absolutely required in that case. All of these are to be evaluated on a case to case basis, and these will have to be documented. That is more important. So this is where I'd like to point out one particular rule which was actually released by Sadaya, right, which is guideline for appointment of DPO within the kingdom, right? Now this particular guideline contains a lot of articles which specifies the minimum requirements for a DPO, what all activities the DPO is entitled to do, and what all reporting the DPO has to do to the authority, and so on and so forth. So taking this particular guideline or the rule as a base, organizations will have to decide on what the governance structure should be, and then accordingly form the governance structure.
Okay. So my question is like here is, when it comes to DPO role, what is ideally the role of, what is the reporting authority of DPO? Like the way we say CISO report as high as possible, internal audit department should report directly to directors to prevent the conflict of interest. So ideally, what is the role? No, what is the reporting of DPO? The reason of asking this question is a lot of viewers who watching this video might be are the deep data privacy analyst aspirants, or who looking for a first job in the data privacy. So in the interviews also, I have seen a lot of people asking these questions. So what is ideally the reporting of DPO in the organization? If I take example of Saudi data privacy, or is it a common, like, is it a common reporting that, okay, no matter which privacy regulation we have, this is a common reporting structure, like they should report to this person, or is it varies?
Okay, so that's a very wonderful question, right? This is a very common scenario we come across in most of our client engagements, where we see that when a client is specifically bound by NDMO requirements, National Data Management Office requirements, when they have a data management team within their organization. Now NDMO has released a guideline about 2 years ago in which a DPO was already specified, and this DPO specifically reports to the Chief Data Officer. Okay. This is only in cases where the organization is bound by NDMO. When an organization is not bound by NDMO requirements, in that case, the recommendation is always that the DPO has the independence, right? They should not be bound by any kind of counter activity. So, for example, a CISO cannot be a DPO because it's going to be a contradictory role.
True.
In that case, they have to report to either the board of directors or they have to report to the chief executive officer, so that there is independence in their role.
Because on one side you can security see, like in case of security they need a transparency.
Yes.
And to transparency they need to collect every piece of data, which is against the principle of data privacy.
Exactly. Yes. That's very true. Independence is the most sought after recommendation from the authority, and that is where even if tomorrow any kind of scrutiny happens for an organization, they will start checking how the DPO is operating within an organization. If the DPO has conflict of interest, that itself is a big red mark for the organization, and they are not complying to the regulation.
But how I've seen a lot of, I don't want to take the names, but I've seen a lot of profiles in India. They mention as a group CISO and DPO.
Okay.
So
it again depends on how the regulator is taking it, right? So especially in KSA, it has been very specifically mentioned, and they have released a specific rule itself for the appointment of DPO, and they have specifically mentioned that that should be independence.
Okay.
So again, it's a wait and watch when it comes to KSA region, because the regulator has still not started the compliance check activity. Now, once they start giving warnings to the organizations, issuing show cause notices, then we'll get to know how the regulator is looking at this.
Okay.
But at least what I have observed is wherever most of the organizations are, even though it's not bound by NDMO, They are trying to establish a data management program, and that is where they are aligning the DPO appointment requirements to the chief data officer.
I agree. So now, like, we build the data governance and all that. What is the next step, which including a policy, appointment of DPO, and all that? So it means in this one more profile we required is project manager, because data privacy itself is a big project, right? Or
Yes.
DPO need to upgrade himself in project management.
A DPO would ideally not be able to manage the project management side because the workload is going to be so much that because especially when it's starting when a company is starting the privacy compliance journey, even the DPO would be clueless about the business itself, right? So the DPO has to understand the business. Only then he or she can actually align the privacy practices to the business, right? So a DPO generally would not have the bandwidth to take care of the project management side. That's where a privacy program manager is generally appointed, and this person exclusively manages all the stakeholders and ensures that whatever input the DPO requires is received by the DPO, and whatever coordination and whatever risk management activities will have to be conducted only with respect to that particular program implementation will be taken care. However, one point to understand is that this privacy program manager is not a very long term role. So generally, what also happens is these privacy program managers ultimately, convert their roles into maybe privacy analysts or privacy consultants or privacy managers itself. Instead of a project manager, they become privacy managers who would be assisting the DPO. So this is also something which I have seen in a couple of companies happening. Now, project management again. One project manager might be sufficient, one might not be sufficient. It completely depends on again on the governance structure and how the privacy program is being implemented.
Because I was making a point for that, because in one of my client meeting they have asked me this question. That's the reason I asked this question to you.
So that's a very valid point, Prabh. I mean, project management is the most important aspect because privacy program, as you know, if you include the basic automation, right, the very basic level of automation such as consent management, DSCR management, and all, the overall program runs for almost 6 to 8 months, and it is a very time consuming and the resource consuming exercise. And on top of that, it's extremely difficult to get the stakeholder buy-in, especially from the IT teams, especially from the legal teams, right, where they have their day-to-day operations and we are just overburdening them with our work. For them, privacy is nothing. For them, the IT team especially wants to take care of whether the IT setup is running up and healthy or not, right? So anything we talk to them, it's going to be a operational overhead, and that's where we need a strong project manager to take care of these coordination and ensure that activities are done.
That's great. So first step was data inventory, data collection. Second step is build the governance and all. What are the important components we need in governance?
Okay.
Policy is there.
Yeah, policy is there, and then
appointment DPO.
Yes, appointment of DPO and formation of respective committees, right? So generally, there is a working group which is going to take care of on the ground challenges. It contains of maybe managers and general managers of various departments who are basically taking care of the privacy compliance journey, and they meet once a week to discuss all the privacy issues and sort it out, right? On the higher level, there is a steering committee which needs to be formed, which is going to be completely accountable for whatever activities are happening within the organization. And this steering committee generally consists of the vice presidents, the CEO, and all the heads of the departments to ensure that their departments are compliant to the regulation. If tomorrow anything wrong happens, the steering committee is going to be the accountable group for that mishap. And that is why it's important to form two kinds of groups. One is the working group at the operational level, and the second is the steering committee at the governance level.
Okay. The reason of asking this, same committee we have in security also, which is called a steering committee. They are the one which is execute the security projects. They are the one who jointly approve the security budgets and everything.
Exactly.
Yeah.
Yes.
It's the same we have in data privacy also, right?
Absolutely. Yes. It's very similar.
So policy is done, DPO has been done, committee has been created. Anything else we need to add in this step?
Absolutely. This is just the first step, Prabh. So after this, a lot of things are still pending. Right now, when we specifically talk about mitigation of risk, right? So what we have done is maybe just 10 or 20% of the privacy program till now, what we have spoken. After this, mitigation of risk is the main activity where DPO gets involved, and he or she has to, analyze all the risks. And these risks are to be evaluated in three fronts. First, the process level risk, which is called as, privacy impact assessment or data protection impact assessments. In this process-wise, risks are analyzed. As I mentioned before, if it is going to be HR onboarding process, then that is considered as one process, and the DPO has to check against the regulation how many risks are popping out. These risks can be data retention risk. These risks can be not having a proper, lawful basis for processing risk, or it can be, excessive data collection, or it can be that there is no data validation at the time of collection of personal data, right? So all these kinds of risks are to be evaluated, and these have to be done on process by process basis. So think about the effort which is required. An organization might easily contain at least 100 to 150 process, right? Because there are going to be at least 10 departments, and each department might have at least 10 process. So the work is going to be extremely high.
So how you handle that? How we handle that if we have so many processes? We go by scenario-based risk assessment, or how we basically pick one process? Like,
no, we go department by department. We
Okay.
Start talking to them. We understand what activities departments are primarily involved in. One very important element is the department might have 20 processes as well, but not all 20 process might directly deal personal data, right? Those might be internal reporting process, or those might be something to do with analytics and all, which might not really work on the personal data, right? So in those cases, we ignore all those processes. We only take only the processes which process personal data. Now, once that is done, then we have to spend time on privacy impact assessments, right? These impact assessments are done through workshops, because if you ultimately send these questionnaires to the departments, they might not even understand what is written in the questionnaire.
Understood.
Right? Over a period of time, they might start understanding it, but in the beginning, they will not understand. So workshops are to be conducted. And once they start filling in the responses, the DPO will start identifying the risks associated. Now, the risk associated might not be the department which is filling in the questionnaire might not be the direct owner of the risk, right? So there is a possibility that, so for example, if a business department is filling a questionnaire, the risk might be related to the IT, right? So for example, if the retention has to be implemented in a system, in that case, the IT team is going to implement it, not the business, right? So the risk owner is going to change. Now, this is where it gets really complicated, because when it comes to privacy, the risk owner identification and acceptance of the risk becomes extremely challenging. Now, this is only with respect to the process which I have spoken about. Now, the second type of assessment which has to be done is at the application level. Now, in the application level, we have to understand whether that application is a front-end application, whether it's a back-end application, whether the respective consent choices are given in the front-end application, whether the consent choices are honored at the back end, right? One is collection of consent, whether it is being flown down to the different internal systems. That is something which has to be validated by the IT teams. So that is the application assessment, which will actually, check the flow within the organization in the IT systems, and identify all the risk. Now, when it comes to application assessments, majority of the risks will be related to IT, unless there is a lack in the policy or procedure itself, right? We can simply say to the IT that you have to implement a retention period for the system, but is a retention policy available in the organization? If that is not available, then it goes back to the legal team for defining the retention periods. So that is where the ownership, again, if you see, even in the application assessment, it's not simple and straightforward. The ownership identification becomes very complex. Now, this is the second type of risk identification. Now, the third is, of course, the third parties and the vendors, right? I know that most of the companies have third-party management, assessments and all conducted. But from my experience, I've seen that they do not cover majority of the privacy requirements and the controller processor requirements, right? If a data subject rights come to my company today, and that has to be honored, then my vendor has to honor that, so that I can assure my data subject or my customer that their data is under the safe hands, right? So I am directly accountable for my vendor's compliance as well. This is where the third type of assessment comes into picture, which is vendor privacy risk assessment. Now, again, most of the companies have multiple vendors, right? So this also becomes very complex and very, very time consuming. And getting the vendors to comply to a regulation, and again ensuring that they are treating PDPL as important as the controller company is treating, becomes extremely challenging. Right? If it's a big company like SAP, Oracle, or any other major players, then they already have data protection regime, and it becomes relatively easier. But if it's a small company which is based out of some other third country, which does not have a data protection regime, then they will obviously not feel encouraged to meet the PDPL requirements, and which is where a dialogue has to be initiated. We have to sensitize them on why this is important, how it will affect the business of both the companies. So all these will have to be discussed, and then ensure that they are also complying to the PDPL requirements.
And when it comes to the risk assessment and all that, when we're doing that, do we involve the other consultant like assurance team or security team who does the assessment for this, or we take all the risk context from privacy perspective?
No, that's a very valid question. So we do consider the teams from cybersecurity, the infosec team, and even when it comes to the legal team and the assurance team, they play a consultation job, because there are certain angles where the DPO might not be able to take a call, right? One example again is retention, right? The DPO might say that the retention has to be for 5 years, but this period is nowhere mentioned in the PDPL regulation.
Okay.
So that particular data might be bound by some other regulation. It might be bound by the labor laws. It might be bound by the competition laws of the region, and so on and so forth. So that's where a consultation will have to be done with the assurance team and the legal team. And when it comes to security controls, a consultation will have to be done with the cybersecurity team.
The reason of asking this question, because when it comes to the assessment context and all that, right? So we have an impact from different vertical, and that is the reason I ask. Okay, like these verticals are required or not. Okay, so we done with the building governance, in which we did risk assessment, policy creations, DBO has been appointed. Any other things we left in this particular step?
Now we have just finished with the identification of risk, right? Now next goes to the mitigation of risk. Now mitigation of risk might have various activities. It might be IT related activities, such as implementation of a consent management system, implementation of cookie management system, right? Implementation of maybe vendor risk management system, and so on and so forth. So IT related risks might come. There might be policy related risks which we might have missed as part of the framework development previous phase.
Okay.
So all these will have to be addressed. Once we address all of these things, once we are sure that the risk is minimal, again, as you know, similar to a cybersecurity program, a risk cannot be zero in privacy as well. There is always going to be a risk, right? Now, how we are managing the risk, and whether the risk is minimal, whether the risk is documented, and all these things have to be taken care by the DPO. And once this is done, then we move on to the training and awareness, where we have to sensitize the company, the employees, everyone across that, why PDPL program is important and how they can start contributing in the future, right? This training and awareness can run parallelly as well, along with the, once the governance structure is formed, it can run parallelly as well. But generally, we keep it towards the end, because once the policy procedures are developed, and once we smoothen out all the program requirements, then we actually understand how the privacy program will implement within an organization, right? How it is going to sustain. So that's why the training and awareness sessions are devised according to the policies, procedures, and tailored according to it. And then we start delivering the training and awareness. Now, this training and awareness, it's very similar to cybersecurity program. You can have webinars, you can have recorded trainings, you can have live
LMS.
sessions. Yeah, whatever case may be, you can explore all the options to spread training and awareness.
So once we're done with the awareness, like how can we give the how can we satisfy this requirement? Okay, we're done with awareness, like we're talking about here attendance records and everything that we have collected.
Exactly.
Okay.
So we do have to give the certification of participation.
Okay.
We will have attendance records, as you mentioned, right? So all these are proof that training and awareness have been conducted, right? Now, this is not exactly the last phase again, right? So training and awareness is just one of the phases. After this, of course, the audit phase comes into picture, because now that you have implemented whatever is required in the regulation, right? Whether you're actually compliant to the regulation or not, this is where the regulator Sadaya, they have released something called as a self-assessment questionnaire.
Okay. It's more like a control self-assessment?
Yes, it is a control self-assessment.
Okay.
So it contains a lot of questions which asks more of yes or no questions, and then there are certain remarks column where you can add additional remarks. Suppose you are partially compliant. Why you are partially compliant, right? So you can write all those things in the remarks section and keep it ready. Now, this questionnaire has not been asked by the regulator yet to be submitted to them, right? But it is going to be asked by them. So the self-assessment questionnaire is going to be the basis for a regulator to start contacting the companies for conducting a regulatory audit.
Okay.
Right. Now, so it is very important to ensure that you have the right data input into the self-assessment questionnaire. And this self-assessment questionnaire has to undergo various reviews. The data has to be very accurate, because if you submit a wrong data to the authority and they start scrutinizing you, then it will become an issue. All right.
Okay.
So this questionnaire has to be followed diligently. Now, once this is done, this self-assessment questionnaire is quite high level, right? It's the first step for them to ensure that companies are complying. The other way in which we encourage companies to keep complying is to have regular audits, annual audits. Similar to how a cybersecurity audit happens, we can have audit procedures developed, audit questionnaires developed, and a regular audit will keep happening at the privacy at the DP office.
Okay.
And that also serves as an input for compliance for the regulatory authority.
Okay.
Yeah. So this comes to the basic compliance requirements meeting, right? As we discussed in the beginning, compliance is journey. It's not a one-time activity, right?
Continuous process.
In the 6 to 8 months, you have ensured that suppose 100 processes are compliant. In the 6 to 8 months, you also know that businesses would have developed almost 20 new processes because the company is growing. Now, who is going to ensure that these 20 new processes are going to comply, right? This is where DPO will have to again start working with the business departments on a continuous basis to ensure that the risks are mitigated. Again, at one point of time, a company cannot be compliant. Again, that's a misconception that if I fill the self-assessment questionnaire today and I put green mark in all the question, I'm compliant. No, that's not the case. Right? There will be some element in which you're going to be non-compliant. It's just that how you're going to manage that risk. It's just that how you're going to manage your overall compliance, maturity in the organization.
And when it comes to the requirement of assessment and all that, so they are pretty much good with their knowledge on DPO part and all that. Just need to understand that part also, because that's very important. Like, the people who are going to validate all these pointers and all that are pretty much good with the law or security and all that. What?
Okay, that's a very valid question, right? So we have very few DPOs who are very well versed with the requirements of the law and who have practical experience, right? Privacy is a relatively new field. It started booming only after the GDPR inception, and still the region is new to privacy, right? Even though there have been certain health regulations, certain financial sector regulations which focuses a bit more on the privacy element, but if you consider other sectors, the privacy element has been nearly non-existent.
Okay.
That's where we have to bring in external expertise if required. We can onboard consultants, consulting companies, or we can onboard individual consultants who can actually help them in developing the privacy program. Now, having said that, if the company has the full capacity to kind of develop their own privacy program, they are confident enough that they understand the law and regulation, and they have enough tie-up and partnerships with the vendors to ensure that they have the automation done. Then they can, of course, go about it, right? So, Prabh, I just want to focus on one point which I missed earlier, right? There's a very common question which I come across, which is related to automation. Whether automation is absolutely mandatory for PDPL compliance, right? Now, automation is an enabler for PDPL compliance. It's never mandatory. The regulation does not state that you have to automate all the processes. What happens is, if you take consent management, right? You might have 3 customer touch points on your website. You might have 3 customer touch points on your physical medium or on your physical forms, right? Now, taking consent from customers, how you're going to take consent from customers on the digital medium and on the hard copy medium, and then maintain it on the database in the backend, and how you're going to honor the consent. If tomorrow I revoke my consent, how you're going to revoke all the processing activity related to me, right? All these things become extremely challenging when it's manual in way. Right. This is where automation comes in picture, and automation helps organization to kind of, enable the regulation. Otherwise, automation is not mandatory. It's just going to enable you to, achieve compliance.
And but nowadays, a lot of vendors are coming with the automation of solutions and all that.
Yes.
Automation of inventory and all. I think that is a turning, game changer for data privacy sector.
Exactly. It helps you in, having a quicker turnaround time. It's much more efficient. For example, the first step we spoke about, right? Data discovery and data inventorization. Think about the amount of workshops we need to have with different business stakeholders with the IT teams to get that information, and that might not even be accurate, right? So once you, rather on the other hand, if you have the tool in place or the automation tool in place, you integrate it with your IT systems and then you start the discovery. You might be able to understand the complete personal data landscape within your organization in 2 to 4 months, which is way more accurate, which is way more reliable, and you can play around with that data, and that also feeds as an input to various other requirements. So once you know the data, it becomes easier for you to manage your data subject rights. It becomes easier for you to manage your consents. It becomes easier for you to manage your ROPAs and so on and so forth.
And that's why once upon a time when we say the DPO takes like a privacy management program takes up to 1 year. Now it is basically cut short to 2 months or 3 months because of inventory automations and all that, right?
Still, I wouldn't call it as 2 months or 3 months. It will still take 6 to 7 months for the complete program to get established. And
there is a two-way to implement. One to pass audit, one to really.
Exactly. Yeah. If it's just a tick mark exercise, then of course it can be done, right? But if a company is really focused, and I have seen a lot of companies in the KSA really focused on this, because even in the Qatar Financial Office, they recently started fining companies for breach. So we are starting to see that trend in the Middle East, that regulators are focusing more on data protection, and because of that, companies are taking the PDPL program a bit more seriously than the other regions.
So as like so we did with the risk treatment. Then what is the next thing now after that?
So risk treatment होने के बाद, as I mentioned, it's going to be training and awareness, and then उसके बाद it's more of managing the compliance requirement on a day-to-day basis. Managing the compliance requirement on a day-to-day basis, we have to go back to that governance structure. जहाँ पे we told we basically need the working group and the steering committee members to be focused completely on the privacy governance part.
Okay.
Now the risk is always going to be live, right? Business departments are going to have new processes in place. They are going to onboard new technologies. That's where continuous risk assessments will have to be conducted in consultation with the working group. Now, if at all there is any hard stop or any kind of clash which happens, that is where the steering committee members also come into picture.
Okay.
Right. And each year, again, one very important thing to note is that the privacy program has to mature. Right. Today, a company might not be using artificial intelligence. Tomorrow, the company might be using artificial intelligence. Right. So, how to adapt this privacy program to ensure that they are actually, in line with the AI requirements.
Okay.
Right? There might be certain modifications required to the privacy policy, which is where annual assessments on the policies itself have to be done, and it has to be reviewed. And these requirements will have to be considered and updated and approved by the approving body within the organization. That is one element. Now, second element is what happens in case of a data breach. Right. This is again operational once the operationalization happens. In case of a data breach, who has to get involved in the breach? Investigating committee. Who all are going to be the key players? What activities are to be done? Right. Once you identify the breach, the next immediate step is, of course, the breach containment. Right. In the breach containment, who all are going to get involved? Whether it's an IT-related breach or is it simply a business-related breach, and how to mitigate that particular breach. Right. So that has to be decided. Once that is decided, then as per the regulation, there are two kinds of communications to be sent out depending on the type of breach. The first thing is to the authority, which has to be done by the regulator. Right, which has to be done by the controller, DPO, to the regulator. Now, this completely depends on the risk of the breach, how much the risk the data subject or the consumer or the employee is going to face because of the breach. Depending on that, there are certain criteria which are going to be defined by the regulator, and based on that criteria, the DPO has to report to the regulator. Similar, second kind of notification which has to be done is to the affected data subjects. So if employee data has been breached in the organization, then the employees will have to be notified on what data of theirs have been breached, how it has been contained, what are the next steps, how they can contact the DPO for further assistance related to containment of the breach, and so on and so forth. So these are the two types of notification which have to be sent out to the data subjects and the regulator. Now the regulator, as soon as they receive this particular notification, they will start an investigation.
Okay.
Right? So the DPO is going to be accountable to lead this particular investigation within the company and coordinate with the regulator. The regulator might impose a fine which can go up to 5 million riyals. Or if it's a very major and an intentional breach, in that case, the accountable person, if it's the DPO, it's going to be DPO. If it's going to be some other, person who's accountable, then that person will be might be imprisoned for about 2 years. So, as you see, it's a very very hefty penalty which the regulator has actually decided to impose, and this is also one of the driving factors within the kingdom to kind of start taking the privacy program more seriously.
Huge money.
Yeah, very, very huge.
I thought so far I was concerned about GDPR. Now it's like eye opener.
Yeah. So again, KSA is ensuring that they are at line with GDPR and the global data protection centers, and that's why they are not really focusing on the other region data protection laws. They are trying to set a standard in themselves, which would actually be a kind of a role model for other regions as well.
And so okay, so we have done with investigation, we have notified. Then what is the next step after that?
Yeah. So once the verdict comes out from the regulator, whether it's going to be a fine, whether it's going to be imprisonment, and once those things are decided, then the organization needs to start working on the corrective actions, why that breach happened and how it can be contained. Right. So the corrective action might be a very easy corrective action. It might be a very difficult corrective action.
Okay.
Depending on the course, the corrective action procedure or the process will have to be submitted to the regulator, and the regulator will keep a close watch on this corrective action, whether it's being implemented as per what is committed to the regulator. And once the corrective action is implemented by the organization, the case is considered closed. And of course, there are going to be internal audits which are going to be conducted within the organization to ensure that these corrective actions are working as per the expectations, and there are no further possibility of risks of breach.
Okay.
Yeah.
And then what is the next step after that?
Yeah, that basically concludes to the breach management side, right? So once you do the corrective action and once you have the risk mitigated, then the breach management side is completed. Now, when we specifically talk, I think we spoke about audits, we spoke about risks mitigation on an ongoing basis, we spoke about policies, procedures, improvement on an ongoing basis, and then we spoke about breach management, right? So these are the primary areas. Yeah. Now coming to the data subject rights, which is also very very crucial for a privacy program. So Prabh, as you know, there are 5 kinds of rights which are enabled in the PDPL regulation, which starts from right to access data to right to correction, right to deletion of data, and so on and so forth. So these rights, even though are very very crucial for PDPL regulation, these are not absolute rights, right? Which means that if I submit a DSR request to any of the KSA companies today, it doesn't mean that the company is 100% obliged to fulfill my right, and that is so because every personal data which the company is processing is based on one or the other lawful basis of processing, right?
Okay.
For example, I might have entered into a contractual obligation with that particular company, which actually requires the company to store my data for maybe 10 years, 15 years, and I would have signed that contract, right? So in that case, the right is not absolute. Similarly, if there is a case, if a legal case is going on between me and the company, right, and at that time I say that you go ahead and delete my data, right? It doesn't make sense. So even in that case, the absolute is
Exceptions are there.
yeah, exceptions are there. So these rights are not absolute. However, in most of the cases, organizations must strive to fulfill these rights,
Okay.
especially which are relatively less complicated, such as right to correction, right to access information, and all. Right to destruction or right to erasure is which is more complicated relatively in an organization, because it's not only about simply deleting the data, right? It's about
Mm.
once you delete a data, it's about how the integrity of the database gets affected, right? How the workflows get affected because you delete the data, right?
Mm.
So right to deletion is never easy, whereas right to access information, right to update or correct information is relatively easy for an organization. Again, when I say easy, it is easy if you're actually having a tool in place or an automation in place. Otherwise, if it's a large organization, you'll have to go through all the databases where my data is lying. You'll have to go through all the physical documents where my data is lying, and you'll have to correct all those information, which is again very very
Time
cumbersome.
consuming.
Yeah. So when it comes to data subject rights, there are 30 days given to an organization for
Mm.
responding back to a right. And if at all the organization has very compelling reason that they are not able to fulfill the right within 30 days, they can extend the timeline by another 30 days by giving a proper intimation to the requester of the right. Right. So
Okay.
maximum of 60 days is what an organization is entitled to take care of. Now, again, the organization has one more situation in which they can decline right, in which if the request is excessive in nature, right? If
Mm.
if I start submitting like 4 or 5 requests per day, which is ideally not required for any data subject, right? It means that I have an interior motive or some other intention to raise this request, right?
Mm-hmm.
So that in that case, I have the right to decline the organization has the right to decline the particular rights request, right? So there are various cases in which an organization can take an exception. However, an organization should not completely depend on these exceptions to decline a request, right? They should strive
Okay.
to fulfill the rights. Ultimately, the intent of developing PDPL by Sadaya is to, give the rights back to the, residents of the Kingdom of Saudi Arabia. With the technological advancements, you get so many targeted advertisements, you get so many, SMSs on a day-to-day basis, and
Mm.
you're really not able to control that in the digital ecosystem, right? This is where Sadaya developed this particular regulation, and companies must strive to fulfill these rights and give back what actually belongs to the residents of the uh, kingdom.
That's amazing. And once we done with this process, about uh, rights and all that, then what is the next step? We can go for it.
These are more operational things, right? So,
Okay.
these are not a cyclical thing or a something which has to be done on a regular basis. These are
Mm.
more operational things.
Mm.
The risk assessments, the rights request, the consent management, the
Mm.
breach management, all of these are operational things.
Mm.
So
Mm.
once you start doing all of these things,
Mm.
then you're actually operationalizing your privacy program, and you're having a successfully running privacy program.
Okay.
And the only way to mature it is to, as I mentioned,
Assessment.
ensure, yeah, assessments, and then having the policies, procedures updated as
Mm.
and when required to ensure that it's percolated across the organization. So
Okay.
this is the basic crux of a privacy program, and the implementation of it.
Okay. So if I summarize that in a sequence, so step one is understand the requirement.
Hmm.
Second step is you doing a data inventory by having a workshop with business team.
Yes.
Third, building a governance which include your policies, committee formations, legal rights, and all that. And fourth step is improvement.
Yes.
Now, if I need to verify, this is the last question. I'm sorry, I'm asking you
No,
so
no
many
problem.
questions. If I talk about if I want to verify the company is comply with PDPL,
PDPL.
what are the things we have to check?
So as of now, on an immediate basis, as I mentioned, it's going to be the Sadaya issued questionnaire, right?
Mm.
That is going to be the assurance to the regulator that a company is complying to the requirements of the regulation.
Mm.
However, regular audits, annual audits, will have to be conducted to verify whether all the businesses are actually complying to the regulation. It's a very similar case of any GRC project where you do the test of design, test of effectiveness, and all these things. Even though we don't call it as test of design and test of effectiveness over here, but these are taken care as part of the privacy audits itself, where you check whether the privacy workflows are working fine within the organization, whether appropriate teams are being intimated if a DSAR rights request is coming, right? Whether appropriate steps are taken if a process has to be fulfilled, and all these kind of things are audited on an annual basis. Now, if there is any major audit finding, that again is going to be reported to the steering committee, and the steering committee has to evaluate what are the requirements, and will have to approve the improvement programs for the privacy program. And this is how the maturity of the privacy program will keep improving. And you can, of course, the organizations can have their own privacy maturity model defined, in which they can start right from the basics to the optimized stage, where they are going to have a fully functioning and operational privacy program.
So, Suhas, thanks for being patient of us, giving the answers to the questions. I have two more questions. Sorry for that. One question is on data transfer on international consideration, where, I want to understand about how does PDPL address the cross-border data transfer, especially concerning about multinational companies operating in Saudi Arabia or outside. So how do you see this as a data transfer? Like how can we handle this issue?
Okay. So traditionally, what has happened is, organizations have followed a data localization requirement because of National Data Management Office, right? And organizations were not really transferring data outside. So with the law coming in, there were initial, impressions given that data could be transferred outside to the kingdom. And recently, again, a specific regulation on data transfer was released, which allows data transfer outside the kingdom based on various conditions, right? So, for example, if a contractual obligation has to be fulfilled, in which the data has to be transferred outside, in that case, the data transfer is allowed, right? Provided that the rights and freedom of the data subject is not getting affected, right? Second thing is for law enforcement or for judicial purposes, in which the data has to be transferred outside. Even in that case, it is permitted, right?
Okay.
The third thing is, suppose the data has to be transferred for maybe some kind of activity in which the contract has to be fulfilled. Even in that case, the data can be transferred outside the kingdom. So various situations are there on which a company can rely on data transfer outside the kingdom. But again, these will have to undergo a data transfer impact assessment again, right?
Okay.
Only in cases where data is transferred. So this data transfer impact assessment is going to contain, assessment against the receiving country, whether that country contains, adequate level of data protection or not. Whether that country, even if it does not contain adequate level of data protection, whether the company to which the data is being transferred, whether it has adequate level of data protection or not. If it is having adequate level of data protection, are you signing a standard contractual clauses with them, right?
Okay.
Or a data protection agreement. The second case can be if it is a group company in which one company is in KSA, the other company is in UK. In that case, a binding corporate rule can be, binding corporate clause can be signed with them, right? So there are various mechanisms in which, through which data transfer can happen. Now, again, the data transfer impact assessment is going to be the basis to understand and decide whether data can be transferred. Organizations have started conducting these, data transfer impact assessments, and they have started transferring the data as well outside the kingdom. It will become much easier once the regulator actually releases the adequacy decision, right?
Okay.
So regulator is currently evaluating various geographies which are having the same level of protection as KSA. And once they release the adequacy decision, then the data transfer becomes much more easy, and there is going to be free flow of data.
Okay. And will it having any kind of impact on when I say data privacy from cloud and IoT perspective? Because there we have different integrations and all that.
Yeah. So again, it depends on the mechanism in which the data transfer has to happen, right? So currently, Sadaya is allowing data transfer outside, even if it is a cloud outside. Right. So I have seen organizations which have a cloud tenant set up in maybe Germany or UK, and the company is based out of the kingdom,
Hmm.
right? And they are transferring, the data outside. But what they are doing is, again, they are conducting the impact assessment, and they are signing the standard contractual clauses. These SECs were released about a month and a half ago, right? So
Agree.
you embed that SEC into your standard contracts, and you ask the vendor company, the cloud provider, to sign that SEC. And if they are signing it, then you're well protected in terms of the data transfer.
Agree.
Yes.
So that perspective is basically really matter, because that's the reason I asked that question, is because when you're talking about the data transfer from a cloud and all that, this is more decentralized in nature. So
That's correct.
having that visibility is very important. But
Yeah, but having said that, Prab, the thing is, I don't think data transfer will be a huge issue, going forward, because I'm seeing a lot of cloud service provider even establishing their clouds in, the kingdom.
hmm,
So, if at all, Google, Oracle, Azure, and AWS, all these providers, they establish their cloud in the kingdom.
hmm.
It's not going to be a big issue at all, and and the companies are not going to really worry about the data transfer outside the kingdom.
Because like when it comes to GDPR and all that, we have this SSE or BCR and all that.
Yes.
So do we have same kind of provision in Saudi data privacy?
Yes, absolutely. So the
Okay.
first mechanism in which a company can rely is on the adequacy decision, whether
Okay.
the company this list will be released by the kingdom regulator,
Hmm.
and this is something which is expected very soon. Once the
Okay.
adequacy decision is released, then all that is required would be a simple contractual update, and the transfer can happen. If at all if the country to which the data is being transferred is not within the adequacy decision, then the companies can go ahead with a standard contractual clause similar to GDPR or a binding corporate rule. When we talk about
Okay.
standard contractual clause, there are four types of contractual clause, again very similar to GDPR, which are released by the kingdom
Hmm.
regulator, which is controller to controller, controller to processor,
Hmm.
processor to processor, and processor to controller. So
Okay.
depending on the type of data transfer and the relationship between the organization, companies are free to choose the contractual clauses and sign it.
Okay.
Yeah.
Thanks, Suhas. It was a great insight we got, and I will be going to disturb you again for the next podcast on India data privacy. And those who are watching this podcast, do let us know. When you want to plan the next workshop with Suhas on India data privacy, because that also providing a great insight in the comment box. But Suhas bhai, it was a great insight I got from Saudi DPL, and I'm sure those who watching this particular podcast also get a great insight from this. Definitely, the first video which you have done called privacy management system, it's also creating a lot of buzzword, and I can see a lot of comments there also. And I'm sure this video also provide a great insight to the data privacy aspirants who are looking forward to comply the organizations, how they have the companies in Saudi to be comply for PDPL. So I'm sure this can be a eye opener video for them. And I'm sure we are kind of first video podcast we covering where we discussing such detail about Saudi data privacy, which I'm sure it can be a great hit.
Absolutely, Prabha. Thank you so much for the opportunity. I'm sure that it's a learning for all of us. So depending on the feedback we get from the comments, we both will also learn on how to improve upon all these things, and we will get different perspective on the KSA PDPL as well. Again, a law can be interpreted in multiple ways,
Hmm.
and I'm really looking forward to reading the comment section where people are actually providing their perspectives.
And really thanks was by taking out the time to share the insight, share your thoughts, share experience and wisdom on data privacy of Saudi.
It's my
Yeah.
pleasure, Prab. It's always good to talk to you.
Thanks, bye. Thank you so much. And this is all from our side to this podcast. Do let us know in a comment box how do you find this particular podcast. And if you're new to the channel, do share your suggestions. And if you're new to the channel, do subscribe to the channel and click on the bell icon to make sure you should not miss the future videos on a similar topic. Thank you, Swaz bhai. Thank you for coming to the session. I'm really grateful. Thank you guys
Thank you
for
so much.
joining this particular session. We're really grateful for you guys who watching this podcast, who making this podcast success. Without your things cannot be possible. Thanks. Thank you so much. Good day. Bye.